afternoon, distinguished panelists, Dr. Chikwendo Madumere and Mrs. Fumi Roberts, who are with us today. Thank you for being here. Good afternoon, delegates. Welcome to today's training session. It's the first presentation in the NBA-ICLE arbitration training series. And indeed, this series is the first of many series to come in arbitration, so this is the foundation training. Our speaker today will be dealing with introduction to arbitration. And the speaker is Dr. Chikwendo Madumere. Dr. Madumere is a 1990 law graduate of Obafemi Awolowo University, Ile-Ife, with second-class honors degree upper division. Whilst at the university, he won the following prizes: Chief E.A.O. Shoneko Prize for Best Student in Commercial Law, Prince Bola Ajibola Prize for Best Student in Commercial Law, Godwin Adoki Memorial Prize for Best Student in Land Law, and Best Student in Administrative Law. He was called to the Nigerian Bar in 1991, having passed his bar examinations with second-class upper division. He had a postgraduate diploma in international commercial arbitration from Kibo College, Oxford University, under the auspices of the Chartered Institute of Arbitrators, UK. He's a fellow of the Chartered Institute of Arbitrators and also has a diploma in financial management. He's a fellow of the Chartered Institute of Administration. He had a master's degree with distinction in petroleum law and policy from CEPMLP, University of Dundee, Scotland. He has a research PhD on the ancestral arbitration rules on transparency at CEPMLP, University of Dundee, Scotland. He is the immediate past chairman, Chartered Institute of Arbitrators, Abuja chapter, and also a chartered arbitrator. He is on the approved faculty list of the Chartered Institute of Arbitrators, UK, where he teaches, directs, moderates, and assesses different CIAB courses from associateship to fellowship. He is a member of the Board of Trustees of the Chartered Institute of Arbitrators, UK. He is a member of the National Committee of the ICC Arbitration Commission and has significant experience in well over 70 arbitration cases, both locally and internationally, on disputes ranging from joint venture, energy and natural resources, construction and infrastructure. He is a member of the Capital Market Solicitors Association and is registered with SEC as a Capital Market Solicitor since 31st July 2009. Before yielding the floor to Dr. Madumere, I'll ask that those who have questions drop them in the Q&A box, and the questions will be taken right after the session. So thank you very much for logging in. I see we have already over 705 participants tuned in. That's encouraging, and I expect that more people will log in too. So I now yield the floor to Dr. Chikwendo Madumere. Doc, the floor is yours. Thank you.
Thank you very much, Chair of the NBA Institute for Continuing Legal Education. Thank you very much for inviting me. And thank you very much, everyone, for joining today's first session in our training sessions on arbitration. I want to also commend the other members of the team, particularly Mr. Omishade and Rachel, for having me here today. Now, what I'm supposed to speak to us on today is introduction to arbitration. And I want to clarify from the outset that what I'll be dealing with is essentially introductory. A number of other speakers, after me will be dealing in depth with so many of the topics I'll be highlighting to us just now. Now, as I said, the first slide in my presentation is on introduction to arbitration. So I want to start off by posing us the question, what is arbitration? We need to understand what arbitration is. And what makes arbitration different from other dispute resolution mechanisms. And I have tried to provide a very short definition by saying that arbitration is a formal, private, and binding process where disputes are resolved by an award made by independent tribunal. Now, from that definition alone, certain keywords are very critical. Number one is that arbitration is a formal process, and then the outcome is binding, is final and binding. Why did I say that? You will find that in arbitration, disputing parties will be required to formalize their dispute in a set of documents, sometimes called a point of claim or statement of claim, or pleadings, or in international arbitration, they call it either memorials or pleadings. So parties will be required to formalize those disputes in a written form, and then attach their exhibits and then submit. The tribunal will also be required to conduct a hearing, in a formal way that allows the claimant first to present his case. Then the respondent will also present his case. And of course, the witnesses of both parties will be subjected to cross-examination, and all of that. But let me make a point very clear. For those of course, all of us are lawyers here. Even though we have said that it is a formal process, it is not, the formality is not, comparable to what you find in court. And I will give you a particular example. In the court, for instance, you'll be required to subject hearings to the Evidence Act. In arbitration, Evidence Act do not apply as a matter of law. Section 256 of the Evidence Act makes clear that the Evidence Act do not apply. What applies to, even though it's a formal process, what applies to arbitration, essentially rules of evidence, rules as to relevance, rules as to admissibility, rules as to, weight, and rules as to, materiality. Those are the rules that apply in arbitration. And again, another keyword you also find from that definition is that arbitration results in a binding outcome. Up until the recent amendment in our Arbitration and Mediation Act, you couldn't say with any amount of certainty that the mediation outcomes are binding. But of course, what we now find by virtue of the new law we have is that arbitration outcomes are also binding, reflecting the Singapore Convention. But one takeaway from the definition I have given to you about arbitration is that the outcome has to be binding. And then arbitration is usually carried out by an independent tribunal, usually made up of either a sole arbitrator or a panel of 3 arbitrators. And then the subsequent speakers will elucidate more on that. But suffice for me to say that usually if it is a sole arbitrator, the law is that the parties will jointly appoint, or if they don't appoint within a specified number of days after notice of arbitration has been given, an appointing authority, will now have to appoint. If there is no appointing authority, the High Court, the chief judge, will now appoint for domestic arbitration. Then for international arbitration, the director of regional center in Lagos becomes the default appointing authority. And then, of course, another word you will also note in the definition is that the tribunal has to be independent. That is very critical, because the tribunal must be seen to be independent and impartial, independent of the parties and impartial of their dispute. In other words, the tribunal must not, be connected to either of the parties in a way that erodes the confidence of the parties. It must also not be connected to the dispute of the parties in a way that also impairs the integrity of the process and integrity of the outcome of the process. So much for definition of arbitration. Now, there are some points you must remember when defining arbitration or when trying to introduce ourselves to what arbitration is. Number one is that arbitration, like I said earlier, is a binding form of dispute resolution. It must always lead or yield or a result into a binding outcome. Number two is that parties can choose, and a dispute arises, they can now frame what is generally referred to as a submission agreement. Now, the difference between those two is that in framing a clause in your contract, you are imagining or you are envisioning or you're envisaging a dispute that could arise in the future. So you are not at that moment in time able to determine your underlying contract in anticipation that dispute might arise, and they do really arise. So that is what we call arbitration clause in a contract. Usually it is said all disputes, claims, or difference arising from or connected to shall be, that is a clause. And you can find it towards the end of every contract. But what if parties do not or have failed to encompass or embrace that clause into their contract? What then do they do? Parties can also have what they call submission agreement. In other words, a dispute has arisen between the parties, and they are now saying, look, rather than litigate the dispute, why don't we explore arbitration as a dispute resolution mechanism? And they can now come together and frame what they call submission agreement. And that submission agreement relates to the dispute, the specific dispute that has arisen between the parties. The only drawback, to this kind of arrangement is that when dispute arises between parties, it's not unlikely that parties may not, be on the same page any longer, for them to agree on a submission agreement. What you will find is that, for instance, the party who is, potentially at fault may be unwilling, to submit to arbitration, or may be unwilling to, to cooperate with the other party in framing a submission agreement. So the best bet remains that for parties to anticipate this kind of situation and to incorporate arbitration as a dispute resolution mechanism in their contract. Now, the next point there is that we must know that arbitrators are in effect private judges. Yes, arbitrators are in effect private judges because the law has them with the outcome of those disputes are cognizable in courts. In fact, they are taken as the judgment of a high court. That is why you can afford to enforce those judgments as a judgment of the high court by applying to the high court for recognition and enforcement of the outcome of that arbitration. So they are in effect private judges. That is what arbitrators do essentially. Now, the next point there is that arbitration is truly international. The arbitrators can be of any nationality and the proceedings can take place anywhere. Now, as we speak, I'm in Kenya. Now, assuming I'm here now to do arbitration, that means that my practice is transcending national boundaries. So that can also apply to any other person who is an arbitrator. So you don't have to practice arbitration only in Nigeria. Arbitration is an international practice. And that means that you can practice it anywhere. And there's a law they call the New York Convention, an international framework. They call the New York Convention. That convention allows arbitral outcomes to be implemented or to be enforced in all the convention states that have signed up to, the New York Convention. So the practice is essentially international. And even though some can also, by reason of their choice or whatever, restrict their own practice, within the borders of their residence. But the international arbitration is essentially an international practice. Now, one of the advantages you find with arbitration is that it allows for flexibility. For instance, if a lawyer files a process at Abuja High Court, the lawyer, both the lawyer for the claimant and lawyer for the respondent, will be bound by the rules of the High Court of the Federal Capital Territory, or the rules of the High Court of Lagos State, or Rivers State, or wherever state. But in arbitration, as a matter of fact, parties can, of their own volition, make a choice as to the applicable rules to the arbitration. And like I said, those are one of the things that parties can agree and or can formulate and impute into the dispute resolution clause, that in the event of dispute, the applicable rule shall be the rules of arbitration under the Arbitration and Mediation Act of Nigeria 2023, or the rules of any other jurisdiction. So you can actually agree as to the rules applicable. That is because of the flexible nature of arbitration, and because of the fact that arbitration runs on the principle of party autonomy. Parties are the owners of the process, so they can elect within the confines of the law the applicable law to their dispute, and that would be, effective and cognizable by any court. Now, the next point there also is that arbitration can take place under the auspices of an arbitration institution, or it can take place ad hoc. Now, there are different arbitration institutions in the world. For instance, we have the Chartered Institute of Arbitrators, we have the ICC, International Chamber of Commerce, with headquarters in Paris. We have the LCIA, London Court of International Arbitration, with headquarters in London. We have the regional center in Lagos. We have the Lagos Court of Arbitration there in Lagos. We have the multi-door courthouse in Abuja. There are a lot of institutions, that you can actually adopt their rules, being the rules applicable to your arbitration. Now, the implication of that is that when you adopt the rules of an institution, it becomes an institutional arbitration. That institution will naturally or expectedly be expected to, to administer that process, isolating the tribunal from, any liaison with the parties. But if parties have not elected any institution as the administrative authority, if parties have not elected any rules of any institution as the rules applicable, there's also what they call the UNCITRAL rules of arbitration. UNCITRAL simply means United Nations Commission on International Trade Law. That is a commission that has framed what they call the UNCITRAL arbitration rules and what they also call the UNCITRAL model law. Countries have adopted and adapted those rules and those laws to reflect their national legislation. Of course, it will interest you to know that the very first version of the UNCITRAL model law was framed in 1985. And the very first rules, or UNCITRAL model rules, was framed in 1978, I guess. And Nigeria adopted and adapted those laws and those rules to reflect the XY Arbitration and Conciliation Act, of 1988. But of course, that the model law has undergone some changes, and then the rules also have undergone some changes. The current version of the rule now is the one of 2013, and the current version of the model law is one of 2006. Of course, our new arbitration law in Nigeria reflects the current versions of both the model law and the arbitration and the current versions of the arbitration rules. So much for ad hoc arbitration and institutional arbitration, and I'm sure subsequent speakers will expand on all of these points that I'm making. Now, somebody will ask at this point, what essentially is the object of arbitration? And this point is very important, particularly speaking to a community of lawyers. It's important to understand the object, so that then frames our disposition and our approach to arbitration, so that we don't turn it into another form of litigation, courtroom litigation. Because some lawyers have this impression that the end of arbitration is actually the beginning of litigation in court. And that is down to the fact that, with all due respect, a lot of us do not actually understand or appreciate the fine lines of difference between arbitration and litigation, and also understand the object of arbitration. So what is the object of arbitration? Now, the object is clearly set out in section 11A of the new Arbitration Act in Nigeria. And it says that the object is to obtain a fair resolution, number one, of disputes by an impartial tribunal without unnecessary delay or expense. As a lawyer appearing in an arbitration, as a lawyer that has negotiated with, for his party and has, enacted a clause reflecting arbitration in a contract, and then a dispute has arisen, and then you have triggered that clause into a proceedings, there's an obligation you bear to ensure that the tribunal that is being constituted must resolve that dispute in a way that is fair to all the parties, in a way that is impartial, and the tribunal is independent, and the tribunal must run without unnecessary delay and unnecessary expense. Now that puts an obligation on you as a lawyer in appointing your party's arbitrator. You must appoint an arbitrator that has no connection with you or with your dispute. Otherwise, you'll be offending against the requirements of impartiality and independence. In appointing your arbitrator, you must appoint an arbitrator that has requisite expertise, substantive expertise and procedural expertise that allows him to resolve the dispute in a way that is fair. Also, in conducting that process, you must conduct it in a way that do not trigger or engender delay and escalate cost. So you must ensure that you are timely in your responses to tribunal orders and procedures. You must ensure that timelines enacted by tribunals are kept. So it's important to understand that obligation which you bear, because that obligation flows directly from the object of arbitration. That is what they call guerrilla tactics in arbitration. Guerrilla tactics simply means this kind of shenanigans or brinkmanship that lawyers do in court. You're not ready to go on with your matter, and then you send your junior who goes there to tell them that yesterday snake swallowed some money in your office, and because of that, you are not in the right frame of mind to go on. Or you can just, frame one manner of excuses, which is what we do in court. That is not acceptable in arbitration, because for every time the tribunal convenes, cost is incurred. And somebody may have to bear that cost if eventually, even if you win, tribunal may have, may take all of that into account, in awarding cost. Somebody will speak to us about cost, so I don't want to dwell a lot more on that. So much for the object of arbitration. Now, there are certain fundamentals that we must keep in mind, around the subject of arbitration. Number one is, we can find it in section 11C of our new arbitration law or new arbitration act. It says that arbitration shall be binding and enforceable against parties to the exclusion of any other resolution mechanism unless the parties otherwise provide or the agreement is null and void. What it means is that once parties have elected in their contract, or once it can be seen from their contract that parties had elected to resolve their disputes by way of arbitration, then that law or that preference must be upheld by the parties and upheld by the court in the event that any party wants to shy away from it. In other words, it must be clear that arbitration must be applied exclusively, without recourse to any other dispute resolution mechanism. And that takes us again to our drafting styles as lawyers. Somebody will speak to us about drafting letter. What the preference of parties is that of arbitration. You cannot say, if there's a dispute, parties shall arbitrate or litigate. That makes it non-exclusive. That makes it unclear as to what your preference is. So it must be clear from the resolution clause that the preference for the parties is to arbitrate their dispute. And once that is clear, it means that parties must implement that agreement. Parties must be held or must be held to comply with that requirement. And that is why the court will give what they call a stay of proceedings if any party wants to resile from that agreement. So that means the agreement is binding and it's enforceable against all. But then also the only exception is that the agreement must not be null and void. The agreement must not be null and void. In other words, it must be written in a way that it is enforceable. For instance, in Nigeria, we know that there are certain aspects of dispute that parties cannot arbitrate. For instance, matrimonial matters. For instance, by virtue of the Supreme Court decision, in a number of IOC-related matters, tax matters. Now, if we are to frame a clause around those subjects, of course, it will be seen or it will be taken that agreement is null and void because it's not something that can be implemented because they run against the express provisions of the law of the land. Now, number 2 point there I want us to keep in mind is that arbitration agreements is an agreement by parties to submit to arbitration any disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether in the legal relationship or not. In other words, you can actually arbitrate both contractual matters and tortious matters, as long as it has arisen out of a defined legal relationship or not. So what it means is that, the point I made earlier about having it in a clause or having it as a submission agreement. So even if you didn't have it in a clause, in a submission clause in your contract, you can, in the event that the dispute arises, agree with the counterparty, to arbitrate it. That you can find also in section 2.1 of our new Arbitration Act. Now, in section 2.2 of the Arbitration Act, you can see that arbitration agreement shall be in, the word there is shall. It shall be in writing. It shall be in writing. So there is no gainsaying the fact that it has to be in writing, because that writing aspect establishes the requirement of consent, because arbitration is a consensual process, and parties are bound by it. So for you to be bound by arbitration agreement, which precludes you from resort to the traditional means of settlement, it must be seen that you had consented to to that arbitration agreement. Of course, that is not to say that there are not instances when non-parties can be bound. That is not within the scope of this discussion, because I'm basically introducing arbitration. But that is an area that we can have a conversation on later on. Now, the further point I made there is that discussions on stay, number of arbitrators, appointment of arbitrators, challenges will be anchored by other speakers. Subsequent speakers will, of course, expound a lot more in all of on all of those other points, challenges, number of arbitrators, and stay of proceedings and all of that. Now, section 51 of our new Arbitration Act says that the tribunal can decide based on rules of law. I want to underscore that point very clearly. Before now, you couldn't decide as a tribunal based on rules of law. You could only decide based on the law of a specific jurisdiction chosen by the parties. But if you're familiar with the model law from 2006, and then the rules, up to 2013, you will find that there's a shift away from specific rules of any jurisdiction to what they call the rules of law. And that is a lot more expansive, as a matter of fact, because those rules of law, it encompasses both customs applicable to a particular trade, custom applicable to a particular industry, mandatory provisions of custom that applies to a particular sector. So what the law now specifies is that tribunal shall apply the rules of law, but that's of course subject to the provisions or subject to the decision of the parties. If parties in the agreement have made clear the applicable rule of law or the applicable law, of course, you as a tribunal must comply with that election of the parties. But if the parties have not, in their wisdom, made that choice, then the law allows you as a tribunal to, of course, in consultation with the parties, to apply the rules of law, as may be suitable for that dispute. Now, stages of arbitration. Stages of arbitration, the kind of subsequent speakers, will speak more on all of these, points. But stage of arbitration, when does it really start? It starts at the negotiating stage of the contract. I had made that point, earlier. A very good arbitration starts from the negotiating stage of the contract. And that is why, as lawyers or in-house lawyers, this training is very important, very, very important. And I commend the NBA for bringing all of this, around the clock training for us as lawyers, because, it exposes us to, very good, useful toolkits in our practice. When negotiating contracts for your client, dispute resolution is one of the critical aspects that parties would take into account before electing to commit to, to any contract, because it's sensible to imagine that dispute might arise in the future on account of that contract. So it is at that stage you must decide for yourself what kind of clause are we going to have. If we say we want to do arbitration, what rules should we agree that will drive that arbitration? What is the seat? What is the place of arbitration? How many number of arbitrators are we going to appoint? So it starts with that at the negotiating stage. Usually they refer to arbitration clauses as the midnight clause. That is so because parties would spend time negotiating clauses that have immediate financial implications. When it comes to the dispute resolution clause, what you find is that they will just go and lift from somewhere and then copy and paste without giving sufficient thought to what they are copying and pasting. When a dispute arises tomorrow, they're not like, hold on a minute, who drafted this contract? Of course you did, because you didn't give sufficient thought to it. So it's important to keep in mind from the outset, what is in need of your client when you're negotiating contract? What are the preferences of clients? So that will inform the approach you would take, in drafting your contract, and drafting your arbitration agreement. Now, after negotiating, the next stage there is drafting the arbitration agreement, either as a clause or as the submission agreement. I've made that very clear, previously. You've negotiated it. It's not, there are a lot of standard clauses that you can actually borrow from, or you can actually borrow and then tweak a little bit to suit your preferences or to suit the preferences of your clients. For instance, Charter of Arbitrators has a standard clause, ICC has a standard clause, ACIC has, even the model law itself has, a prescription of what a clause in arbitration, should look like. So you can actually borrow from any of those standard clauses and then adapt it to suit your contractual preferences. So you can do that in a clause in a contract, or if a dispute has arisen and then the parties have come to an agreement that, look, rather than go to court and litigate this dispute, we'll rather arbitrate it. So you can also use any of those to conduct as a way of establishing the agreement to arbitrate. Now, are you hearing me clearly?
Yes, Doc, we are hearing you clearly. Very well.
Great.
The
Great.
few breaks in between, but it's been clear as is. Thanks.
Okay. Thank you very much, sir. Thank you. So now, a tribunal is constituted, by way of the procedure elected by parties. Parties had outlined what will happen in the event of a dispute. For instance, you had said in your agreement that when a dispute arises, if it's a sole arbitrator, two parties will liaise with each other and then appoint a tribunal. Or in the event of failure of either party to respond in a way that is cooperating, then you after a number of days, the other party can give notice to the default appointing authority, usually the chief judge, for the basic arbitration, then the director of the Regional Center for International Arbitration. So and once that tribunal is constituted, tribunal will be expected to drive the process acceptably in a very efficient and effective manner up until the final outcome, which is the final award. And then again, how is the agreement triggered? Because the arbitration agreement in your contract is dormant up until when a dispute arises. So if a dispute arises, how do you trigger it? The arbitration rules very clear as to how to trigger that that clause in your contract. Of course, you trigger it by serving notice to the other party, what they call arbitration notice, or the notice of arbitration. Of course, there is a template of what that notice must contain. For instance, it must contain the names of the parties, the counterparty, the claimant and the respondent. It must give a brief synopsis of what the dispute is. It must also give a brief indication as to what your claim is. it must also indicate your preference as to the applicable rules, applicable law in the event those things are not in the agreement, or perhaps import them from the agreement if they're already there. Then it must give indications as to who your arbitrator appointed is, or your suggestion is, or the seat and all of that. And the law is that once that notice of arbitration is received by the other party, then the arbitration is deemed to have commenced. So it's important to, as lawyers, understand the requirements of the notice of arbitration and what you should reflect in that notice. Okay, so much for that stage. Let's go on to the next one, to slide 7. Slide 7, arbitration as a practice. What do I, what is it that I must do as an arbitrator, and what obligations do I bear? Now, this is important. I put this slide here for the fact that I'm speaking to a community of lawyers, and which is why I commend the NBA and I commend the chairman of the Institute of Continuing Education. It is not unlikely, or it's not unusual, to find lawyers as make the assumption that because I'm a lawyer, I can be an arbitrator. That is not correct, with all due respect. That is not correct. Arbitration is an area of practice. It has its own methods, techniques, and requirements, and you must be familiar with those methods for you to thrive in this area of practice, which is why training is very important, which is why what we are doing is very important. Of course, I accept the fact that the methods of arbitration are adjudicatory in nature. Yes, it is adjudicatory in nature, but there are things I've seen lawyers come to arbitration and be citing evidence out to me, and I'm like, hold on a minute, where is it coming from? I've seen lawyers come to arbitration and be filing motion on a matter that should take a simple letter. And I'm like, they're just trying to replicate before the tribunal what they are used to doing in courts. That is not proper. That's not proper. And in arbitration, it's very unusual for a tribunal to refuse to admit any document. Very, very unusual. Not because they will rely on it, but because they want to ensure compliance with the requirements of due process, which is an obligation every tribunal bears. In court, you will raise objections as to proper custody. That is an objection that is alien or totally strange within the arbitration space. So these are things that you must be familiar with as an arbitrator, or as somebody aspiring to go into the field of arbitration. So I commend you once again for taking time out to part of this training, because I mean it exposes you to a lot of things that you find very useful in your arbitration practice. So arbitration has its own methods. It has its own techniques. Both the commercial arbitration area and investment arbitration area, it has its own methods and its own techniques. So it's important to be familiar with those methods and not just go under the assumption that I'm a lawyer, I can do it. That's not correct. In arbitration, we conduct it in a very friendly manner. You hardly see a lawyer in arbitration standing up to address the tribunal. Everybody sits down. Everybody is required to be very friendly, very cordial. We have tea breaks, we have lunch breaks, even though parties pay for it, of course. But I mean, it creates that ambience of friendship, ambience of tranquility and calmness. And then I've made that point again as number 2. So granted, it's adjudicative process, but training and retraining remain desirable, both from the point of view of counsel in arbitration and arbitrator. So it's important to always expose yourself to trainings and retrainings, because these things, the rules are dynamic, the practice is dynamic, and you must be up to speed with the changing landscape of arbitration. For instance, we now have a new arbitration law in Nigeria. How many of us are familiar with the law? How many of us will take our time to read and be familiar with that law as counsel? How many of us are familiar with how to, conduct hearings, using the facilities of technology? How many of us are familiar with how to tender documents using the innovations of technology? Same also goes with the tribunal. Arbitration is rewarding, yes. Because of that, you want to accept appointment, even though you know you don't, even you yourself know that you don't know jack in arbitration. And I do not mean to insult anybody. I'm just, being frank. And I say that with all due respect. You accept the appointment. You don't understand the obligations you bear with regards to understanding the procedure. You also don't understand the obligations you bear with regards to understanding the substantive law applicable in that dispute. Of course, you know that in the court, the High Court judge takes land matters, criminal matters, maritime matters, family matters, and all matters, because the judge is assumed to know all the law. But in arbitration, one of the advantages of arbitration is that it allows parties to exploit the technical expertise of the tribunal. That is why you can have an engineer be a chair of a tribunal or a co-arbitrator in a tribunal, because there's something he's bringing to that tribunal. So for you as an arbitrator, somebody approaches you on a dispute involving maritime matters. And for crying out loud, you don't have any knowledge of maritime, but you don't accept that appointment. You are undermining the case of the party who has appointed, because you will find that you may not be able to contribute as you would have contributed if you were familiar with that subject matter. So it's important for you, to expose yourself to all of these kind of trainings that puts you in shape in the event an appointment comes, both from the legal side as a lawyer and from the arbitrator side as an arbitrator. In fact, it's even worse for the arbitrator to even accept appointment when you know you cannot, in all honesty, conduct that arbitration in a way that satisfies the burden, procedural burden, and the substantive burden that you bear as a tribunal. For you as an arbitrator, the worst thing that can happen to you is to produce an award that is thrown aside by the High Court. It's award that is set aside. That is a very bad thing for you as an arbitrator, because your reputation stands on the quality of the outcome that you produce. And the signature of your expertise is the quality of the award that you write. So if you accept an appointment because of the pay, and then your award gets thrown away, I bet you it's a question of time. People will get to know about it, and nobody will appoint you again. So it doesn't do your practice any good to accept appointments when you know you're unable to discharge the obligations of that appointment. And which is why it's important to, take time out and learn, the tenets and the demands of the craft of arbitration. And then with regards to counsel, like I have mentioned earlier, you must be aware, working in liaison with your party, what your party wants reflected in its arbitration agreement. What your party wants. For instance, your party has a dispute that has to do with international trade. Don't just go appoint somebody because he's your friend, somebody who cannot aid you, because the person you are appointing is not going to sit in tribunal as the lawyer of the party appointing him. No. That is why you must have a lawyer. But the arbitrator you are appointing should be able to understand the point you are making, and should be able to let the tribunal understand that point, for the tribunal to now make a decision as a tribunal with him being part. You cannot say, because you have appointed me, I should go to the tribunal and be your lawyer. I will never do that. Never. I can never do that. The best practice is for the party appointed arbitrator. What I do in my practice is that if I am the presiding arbitrator, at the conclusion of the hearing, in our deliberation, I will ask party, my co-arbitrators, could you please explain to the tribunal your understanding of what the case of the claimant is? Same thing for the respondent. So how can they now explain to the tribunal unless they understood your point of view? So it's important to have an arbitrator that understands, that is very familiar with that area of dispute, to be able to both help you and also help the tribunal in arriving at a very, acceptable, outcome. And then I said that counsel must also be aware of the object of arbitration, which I have talked about, and therefore not indulge in guerrilla tactics that may impair the advantages of arbitration. I've said that, already. And then as a tribunal also, you must understand that the obligation you bear is to produce an award that is binding, that is valid and enforceable. As a tribunal, the whole purpose is like a woman who wants to prepare. It's like a woman. Sorry, please let me increase my volume a little bit. It's like a woman who wants to prepare, soup, edikaiko soup. She goes to the market to buy all of those ingredients. All of those things will come together in that dish that she serves on the dining table. That is what your award is like as an arbitrator. Everything that goes into that process, from the hard work of the lawyers, hard work of the witnesses, the cost of the parties, everything else, hard work of the tribunal itself, everything else must lead to an outcome. That outcome is to have an award that is valid and enforceable. So you must understand as a tribunal that that is an obligation you bear. And that is why you must ensure that you're up to speed with the demands of that craft. Okay? And then also, you must understand that you have an obligation to sustain the trust of the parties in the integrity of that mechanism. As lawyers, we are very familiar with what things that play out in court. When you see a judge in court sitting, behind him you will see the crest of state, and beside him you will see a policeman. That tells you something. That tells you that the authority of the court flows from the state, flows from the law. But when I sit as an arbitrator, I'm not sitting on the basis of any crest of state. I'm sitting on the basis of the trust of the parties in my person, and also their trust in the integrity of the process. So that means that I must ensure that I conduct that process in a way that sustains that trust of the parties, both in me as an arbitrator and in the integrity of the process. So you must understand that. And one sure way of doing that is to be sure that you as an arbitrator, you're familiar with the procedural and substantive expertise required before taking up the appointment. I mean, if you don't understand, I don't want to go into specifics, but I know I have been in tribunals that I'm not sure I enjoyed. If you have the misfortune of being in a tribunal, particularly where the presiding is somebody who is not trained, I mean, that's not an experience you want to have, to be honest. So you must ensure that as a tribunal, you understand the demands of that process, demand of that mechanism. And then, like I said earlier on, and you must be aware of the obligation to produce an enforceable award, a valid and enforceable award. That is critical. That is very, very central to your role as an arbiter. Now, to round up, now I want to talk about the connection between the arbitral process and the court system. Now, we started off by, if you recall my definition from the outset, I said arbitration is a private dispute resolution mechanism. And you also find in the law is very clear that courts must not interfere unless in instances where they've been asked to interfere. At the base of arbitration is the principle of what they call freedom of contract. If you have elected to arbitrate freely, the court puts a stamp of judicial imprimatur on that agreement, and the court will restrain you from resciling from that agreement. That is why the court will have a stay of proceedings and then point you back to arbitration. So there is a little bit of interaction between the arbitral process, even though it's a private one, and the court. So that's the kind of thing I want to talk about in this closing, slide. Somebody, Professor Jan Paulsen, calls it the paradox of arbitration. It says that that even though it's a private dispute resolution mechanism, but it relies on the support of the court to sustain it in a way that's efficient and effective. Professor Laleve also had the same view, that it is a paradox that even on one arm you claim it is private, the court, the court should stay away. On the other hand, you also require the support of court at critical points in the cycle of that process. So what are those critical points that arbitration fall back to the court or to the judiciary, for implementation of the demands of the mechanism? Number one is prior to the constitution of the tribunal. Like I said earlier, parties usually in their agreement will specify that arbitration is their choice of dispute resolution mechanism. But you also do find that sometimes when there's an attempt to trigger that agreement, one of the parties, the counterparty, may not respond as required, or may even indulge in acts that may seek to frustrate that agreement. In such an instance, you could make a recourse to the High Court as a default appointment, to the chief judge of the state. In the new law, it's very clear, that the court there means the chief judge of the state. That you not make recourse to the chief judge, to sustain the life of that arbitration by appointing the arbitrator either for the defaulting party or for both parties who had not reached an agreement. That is number one. Number two, before also constituting the tribunal, the subject of dispute might be in danger of being eroded. In the new law, it makes a provision for what they call emergency arbitrator, which is a mechanism that allows an arbitrator to be appointed before the main tribunal is constituted. And it also says that parties can actually make recourse to the court, for an order, for an interim order, that seeks to preserve the subject of dispute or dissipates and makes the arbitration no longer sustainable or no longer attractive. So that is one way the court can support arbitration prior to the constitution of the tribunal. Also, during the process of arbitration, courts can also come in very handy. For instance, in compelling witnesses, courts can come in handy. For instance, in challenging the arbitrators or challenging the rulings or decisions of tribunal on jurisdiction, courts can come in handy in all of those areas, or compelling a third party. Of course, that a tribunal cannot compel a non-party to the tribunal. It cannot make any order against a non-party. So what if the non-party is a vital witness? Of course, either of the parties can, then go to approach the court for the court to, make an order compelling the non-party to appear before the tribunal and to give evidence. Those are instances, that the court can support. When you see parties trooping to London, to Paris, to New York, to Switzerland for arbitration, it's all because of all of these intangential support that tribunals enjoy in those jurisdictions. Apart from the fact that they have laws that are arbitration friendly, they also have a judiciary that understands their role, their complementary role to the, to arbitration, and they are playing those roles very willingly, at every turn, providing support to arbitration, both before and during the, during the arbitral, process. And then after the publication of the award, of course, that as lawyers, we understand what the principle means of what is it now? That you have become fontis official, principle of fontis official. Once the tribunal publishes award, the tribunal will be seen to be fontis official. In other words, you cannot go back to that process. Of course, that is subject to some provisions in the law that allows for correction of the award, by way of either publishing a new award that seeks to correct or seeks to adjust or making a further decision which you had omitted to do or in the course of during the life of the arbitration. But generally, what I'm talking about is that after the award, the tribunal becomes funds official, subject to what I said previously. So it is the court that you now make recourse to. If there is a non-voluntary compliance with the text of the award, if the award debtor, for instance, refuses to implement the demands of the award, of course, you'll be required to enforce the award by going to the High Court. But usually it's done through motion, originating motion, attaching the agreement and attaching the award for the court to recognize and to enforce the award as a judgment of that court. And of course, also you also know that the courts also will also entertain applications for setting aside on very limited grounds, usually procedural infractions, of the award. So with these few points of mine, I hope I've been able to introduce to us the subject of arbitration, and I'm very much open to your questions because we still have time. I want us to engage a lot more in question and answer rather than me just talking, endlessly, from this end. Thank you very much, Mr. Chair. I'll yield the mic back to you, sir.
Thank you very much, Dr. Madumere, for a very brilliant presentation. I don't think anybody could have introduced this topic any better, but we'll reserve the thank yous for later on. I can see that Mrs. Roberts is online. I don't know whether she has any comments on the session before we move on. Mrs. Roberts, are you there? Okay, I mean, we will take Mrs. Roberts' views subsequently. Peace, are you ready to take on question time? Hello, Peace. So whilst we're trying to get that.
Yes, I'm ready, sir. Yes, sir. Can you hear me?
We can hear you, but we can't see you. So you can draw the question from the Q&A box.
All right.
If you put your video on, that would be nice. So Peace, we can't see you yet. I must congratulate all those that have attended. So far, we've had about...
Yes,
we can see you now. Please go ahead.
So thank you so much, Dr. Madumere, for that excellent presentation. Very quickly, I'll go through the questions that have been asked in the Q&A session. So the first question was asked by Jamia Sahid. He said, thank you so much for the half presentation. Please, is the tribunal different from the arbitrator? I thought it's the same as saying the court and the judge. I heard doctors in the tribunal will ask the arbitrator what's the case of their client is to know if they appreciate their client's case. So I think the question they're trying to ask here is that is a tribunal different from the arbitrator?
Thank you very much, Peace.
Yes, thank you, sir.
Thank you very much, Peace. My apologies if I was not clear in expressing my thoughts in that context. Usually the arbitrator is a tribunal, and I thought I made that point early on in my presentation. The tribunal could be the sole arbitrator or a three-man panel. That is, a panel that has 3 arbitrators. So the tribunal, when you talk about tribunal, it means you're talking about the arbitrator, which could either be 1 arbitrator or 3 arbitrators.
Thank you, sir.
Thank you very much for that question.
Thank you, sir. So,
sorry, please, just a second. Doc, it might help if we stop sharing the screen. Thanks. Please go ahead.
Okay, so I'll go with the second question. It's asked by Freda Odige. I don't know if I pronounced the name properly, but its question is, do magistrate courts have jurisdiction on arbitration? So I think you're muted.
Sorry, that's a very interesting question also. The law is very clear. Courts, as defined, in our Arbitration and Mediation Act, simply means the High Court of the state or the Federal High Court. So magistrate courts do not have any connection with arbitration. Thank you.
Thank you, sir. And the next question was asked by Loretta Mukuru Osiobe. How is the application to the High Court to recognize an arbitral award done? What is the procedure, sir? That's the question asked.
All right. Thank you very much for that very useful question. But I thought I also made that point earlier. And after the award is made by the tribunal, evidence shows that in many cases, the losing party complies voluntarily with the demands of the award. But where there is a non-voluntary compliance, the law is that you will be required to approach the High Court for what they call recognition and enforcement. It is usually done by originating motion or notice, and you attach the agreement to arbitrate, and then you attach certified true copy of the award. Yeah.
Yes. Thank you, sir. The next question is an anonymous attendee had asked question. Said, is there any forum or avenue where a lawyer can learn practical skills of arbitral proceedings, just like a new lawyer learning by coming to courts and listening to how submissions, prayers, arguments, and other things are done? And the person asked two questions actually. The second question is are you saying that a lawyer who has learned arbitration but has not gotten any practical skill by way of appearing in an arbitral tribunal should not take up the appointment? So they asked two questions. I think the first one is the avenue. How can they learn practical skills? And second, if a lawyer who has not learned these skills cannot take up arbitral appointments.
All right. Thank you very much, Peace. Number one, I'll answer the second question first. Now, when you take up appointments as an arbitrator, you are taking up appointment to perform a role. And that role is to enable the tribunal to produce an award that is valid and enforceable. Now, if you're not able to provide that role in a way that establishes the outcome that is valid and enforceable, it will be inadvisable, in my view, to take up that appointment. Now, there is no law that says that you must appoint somebody who understands arbitration. No law, because it is said that every arbitration is as good as the arbitrator. You must sink or swim with the arbitrator that you have appointed. If you appoint a person who do not understand the ways of arbitration, you'll be doomed, because you have an award that you cannot enforce. Now, when you file a matter in the High Court claiming 10 million naira, for instance, the filing fee may not be up to 5,000. When you file the same arbitration matter in an arbitrator for 10 million, they're going to assess their fees based on a scale of charges, which may not be less than 2 million or 1.5 million. That is not the kind of money parties will spend, and then you don't give them an award that can stand scrutiny. So it is important to therefore appoint people that have, expertise that can give you the outcome that you can, enforce. But that is not compulsory. I have to make the point very clear. There's no law that says you must appoint A or appoint B. It is entirely up to you, because arbitration is run by the parties. Whatever choice you make, you will sink or you swim, with that choice. That is number one. Number two, as to forum for learning. This is MBA training, but let me take liberty of your question to now expand it a lot more. What MBA is doing for lawyers is very, very laudable. It's exposing lawyers to, understanding different areas of practice, arbitration being one. So I've seen trainings in criminal, matters, trainings in civil matters and all of that. But there are also institutions that run trainings in arbitration. Am I aware of Chartered of Arbitrators? Am I aware of ICC? Am I aware of other institutions that run and certify members as having expertise in arbitration? So it's for you to find out which of these institutions are you comfortable with, and then take their trainings, and then get to learn the ropes in arbitration, and then you grow in the knowledge of arbitration. Thank you, peace.
Thank you so much, sir. I think that's very interesting. So just quickly run through the order of questions and
please can I interject for a second, right?
Yes, please. Yes, sir.
Okay, so Dr. Madmer, I think this is quite a good point to ask this question, because one of the things we try to do at the Institute is to, as you say, expose people to new areas of law. But one of the biggest challenges that people have is that they want to understand the practical steps that one should take in order to start building some knowledge and expertise, practical expertise in that area of practice. So for instance, I would like to hear a bit about your experience and the experience of others whom you've mentored, about what practical steps they can take to get to the point that they either become registrars, secretaries, or appointed as arbitrators in proceedings. Thank you.
All right. Thank you very much, Chair. That's a very, very valid question that you have asked. Now, I will just share my testimony as an answer to the question that you asked. Now, I had practiced law for 17 years before I got to know anything about arbitration. At that point, I was trying to make a career, change. I was trying to make, dive into a new direction in my career as a lawyer. And then I realized that this is an area I have interest in. I started running around, taking trainings all over the place. When I started out, to be honest, I was told that don't even bother. This is an area that is very closed. It's a cartel, it's a cabal. They will not allow you in. I say you should not worry. Justice Kayode Shaw of blessed memory said something which I still hold very dear, to my heart. He said, no matter how bad the system is, there's always room for merit at the top. And I've tried to internalize that statement, personally. And what it means is that if you make up your mind that this is an area you want to develop a niche in, then it obligates you to, number one, begin to take trainings that enables you to be certified. Number two, begin to attend conferences so that people can put a face to your name. When I started out, a lot of people said a lot of things to discourage me. I said, no, that's what I want to do. And immediately I finished my certification, running here and there, conferences, calling up people. I can mention names of people that I used to call, sir, please, if you have any requirement of so and so person, I'll be available to help you. Create relationship with people that you want to follow their footsteps. It's not the mentor that looks for the mentee, it's the mentee that looks for the mentor. So it's for you to seek out the people that that should provide guidance to you. And then also acting as registrars for tribunals. In the Abuja chapter of Chartered Institute, we have a practice that says that senior members should always encourage the young members by getting them in as registrars. And I'm sure also in Lagos also, such thing is also being done. So but people cannot appoint you as a registrar unless they know you. So it's for you to keep yourself busy. They have what they call the young members group in different institutions. join the young members group and be active, participate, let them know you. And for me, I can say that for me, I mean, God was just helpful to me in a way that I don't understand, because not too long after I started out, I got a breakthrough internationally. You know, I was appointed an arbitrator in Kenya and other places, and it's been from one level to another level. So the important thing is that you have to be ready. Somebody said, success means preparation meeting opportunity. Before complaining, ask yourself, are you really prepared for that opportunity that you have been crying for? Get yourself ready. Get certifications, get trainings, and academically also improve yourself. Legal practice has gone past the era of having only the first degree. That is the truth. Improve yourself academically. What do people know? And then also try to, perhaps, if you're very good, like myself, I know I write better than I speak. I'm a lot more comfortable writing. Write articles. Create awareness around your practice. Create a network around your practice. And before you know it, one thing will lead to another, and the rest, as they say, will become history. My chair, I hope I'll be able to answer you.
I couldn't have asked for a more practical answer to that question. And I must thank you for your directness and candor with that question. I think that all that we do will be a waste if people just pile up the knowledge and don't see practical examples of how you get on the ladder. And so thank you for making it easy to know how to start. So thank you.
Thank you, sir.
Please continue.
Sorry, thank you so much. I think the next question is, what is the major difference between arbitration and mediation? I think there are a couple of questions around that.
Okay. That question would have been a lot easier to answer if the new law had not been passed. But of course, the new law has been passed. And so, but of course, we still have, the major differences. Differences in the sense that in arbitration, once you have agreed to arbitrate, one of you cannot resile from it. So there's what they call default proceedings in arbitration. And so which means even if the other party is not willing to continue, as long as the other willing party is able to sustain the requirements of the arbitration will still run through. And then the outcome is very binding. But in the new law now, even though in mediation, one party can walk away and that is the end. But if eventually you don't walk away and you follow through, then you have the settlement agreement. That agreement is still binding on the parties. So the major difference is that, and the arbitration is also a lot more formal. Arbitration is a lot more formal than what you have in mediation. For instance, in mediation, there's what they call caucusing. I don't know whether they still do it now. I'm sure Mrs. Robert will speak a lot more, on that. Caucusing is a process that allows you as a mediator to meet the parties individually, understand what their grievance is and what their interest is. You can't afford to do that in arbitration. You can't afford to meet one party without the other party being present. That is number two different. Number three different is that in arbitration, the emphasis is on the right of the parties. In mediation, the emphasis is on the interest of the parties. People can be fighting over something. For instance, without due respect, for those of us who are from the South, a particular state in the South, if you touch them, the next thing you hear is that you hear from my lawyers. It's not because he really needs that case, but because he needs to let you know that you can't tamper with his ego or his self-respect. So that going to court may not be his interest, but going to court just to establish his right. For instance, there's a story that is told about a land matter in Onitsha. That land matter lasted for over 30 years. The lawyer used the procedure of that land matter to train his son, who became a lawyer. The son got involved into ADR and arbitration. So one year, the father traveled for his vacation, and the son was the one in charge of the chambers. And they went to court on that land matter. He saw the lawyer on the other side and said, sir, this matter has been in court for over 30 years. Don't you think we should explore resolving this matter amicably? The man said, well, I'm open to it if you can do it. They met subsequently. One thing led to the other, and within 1 week, they were able to resolve that matter. The young man, who was very naive, happily called his father in London, said, Dad, you know what? This matter, you have been in court for over 30 years. Do you know that within 1 week, I've resolved it? The father didn't talk for the next 5 minutes. The man was saying, hello, Dad, are you there? The man said, what did you say, that you have resolved what case? He said, that land matter. He said, you can't be serious to resolve that case. That case, it was from that case I trained you in the university. and then you have resolved the case within 1 week. He said, you cannot kill the goose that lays the golden eggs. So you can see that in litigation, the emphasis is essentially on rights, just like you also have in arbitration, even though it's a lot more, it's not as express as you have in litigation. So those are, for me, the kind of differences you have in mediation and arbitration. I can see a lot of people are laughing because of the joke I shared.
Please, next question.
Thank you so much for the very extensive difference you highlighted. So I'll go to the other question. An anonymous attendee had asked, can awards at the tribunal be appealed?
No, in arbitration, you don't have appeal against any award. You can only challenge it for setting aside. And that is for a reason. You don't challenge an award based on implementation of a right law in a wrong way. In fact, under Section 55 or so of the new law now, it has even removed error on the face of the award as a ground of challenge. You can only challenge an award based on certain procedural infractions. So you can only challenge for set aside, not appeal. You cannot appeal. The award. It's important to have that in mind. You don't appeal against an award. You only apply to the High Court for setting aside. Yeah, please go ahead, please.
Thank you so much. The next question, he said, will it be ethically wise for an arbitrator to allow judicial decision influence his award?
That is a very, very important question. That is a very, very important question. And that takes, and that answering that question can actually take me another 30 minutes, because that takes me to a topic they call delocalizing international arbitration. Now to answer your question very, very, very clearly, it would be too risky for you as a tribunal not to take cognizance of the law of the place of arbitration. For instance, if the law says that tax disputes are not arbitrable in Nigeria, for instance, I couldn't, as an arbitrator, take up such appointments or run a tribunal to arbitrate a tax matter. If the law says that matrimonial matters are not arbitrable in Nigeria, I couldn't, as an arbitrator, take up appointment and sit in the tribunal to arbitrate a matrimonial matter. So yes, it is proper for you as a tribunal to factor in the law of the place of arbitration or the seat of arbitration. But internationally also, apart from the law, remember, in the presentation I made to you, I said rules of law. Now, what if there are rules of law, for instance, conventions of that trade that supports the award, even though not cognizable under the seat of arbitration? So it's something that you need to weigh properly before implementing it. So my direct answer to you is that it is proper for a tribunal to take into account the rules of the place of arbitration, but then also that can also be on the basis of it should be treated on case-to-case basis, taking into account other variables. Yeah.
Thank you, sir. Thank you so much, sir. So the next question is from Abu Bakar Sadiq. Usman. He said, my question is, in drafting arbitration clause, is there a particular format? And what is the implications of not adopting the format?
So in drafting what, please? Drafting what?
Arbitration clauses. So is there a particular format you must employ? I know you're giving, you talked about model clauses.
Yeah. I'm sure other speakers will also speak about it, but there are some model clauses and they are online actually. If you look at the model law has given you, a template. If you also look at the Chartered Institute of Arbitrators, there's also a template. ICC rules of arbitration also has a template. Generally speaking, it says that all disputes, claims, and difference arising from or connected to. So those are the standard words that you will see in any clause, but something that you can get very easily, online. But if you require any assistance, I'm sure if you talk to the chairman, I can send to you so many that he can share with you. Yeah.
Thank you, sir. Thank you so much, sir. The next question is from Patricia Owokike, and she's asking, please, I want to know if all parties in the arbitral process must be lawyers.
When you mean parties, you mean the people representing, the clients?
I think that would be the implication. Perhaps she's asking about the counsel.
All right. Now, that is one area that the thing is still evolving in Nigeria. That is one area that, the practice is still evolving in Nigeria. You know that under our Legal Practitioners Act, you couldn't defend a party in any adjudicatory matter unless you were a lawyer. That is unlike in India, even in the UK, you can practice as an arbitrator or even as counsel without necessarily being called to bar there. But in Nigeria, you must be called to bar before you can, practice as a lawyer here. But also, you don't have to be a lawyer also to make some preliminary representations. But then if you have to be announcing appearance in a matter, there's an ongoing effort actually, I think from the NBA or from some senior members of the bar asking for an amendment of that law that allows people who are non-lawyers or from other jurisdictions to come to Nigeria and represent parties in arbitral proceedings. Yeah.
Thank you. So another question is from Edirin Eragari, and he's asking, or she is asking, can a claimant who initiated an arbitration proceeding but due to financial constraints as regards the arbitrator charge or elect to proceed for litigation to ventilate or resolve the dispute? So if you have agreed to go through arbitration, can you elect to use litigation instead?
Unfortunately, no. You cannot. Once you have an arbitration agreement, you will be required to follow through that process. But luckily for you, there is a provision now in our new law that is called third-party funding, provision, which allows third-party funders to fund arbitrations now, even if the parties don't have the money. So it's like taking loans now, or taking money in a bank to build a house. So what will now happen is that if you have a case that is before an arbitration, tribunal, or you want to commence an arbitration, you can actually write a third-party funder telling them that you have this matter, and then for them to assess the strength of that case, whether it is a case that can succeed. So they can actually decide to take it on and to fund it for you, with the agreement that they will take a percentage of whatever monetary damages that you win at the end of the day. And that is one thing that's going to boost this practice in Nigeria. Third-party funding. Yeah.
Thank you, sir. Awuwa Adamu has asked the question, and I think he or she is asking that does the reliance on judicial authorities make a critical point in an arbitral proceeding weak? So if you rely on judicial authorities, would it make your arbitration proceeding weak?
No. It doesn't at all. It doesn't at all, because in your submissions to the tribunal on points of law, Of course, you will amplify those submissions by reference to what you believe the courts have held previously on those points. For instance, if you're raising a matter of agency before a tribunal, and you have authorities that where the court have defined what an agency means, of course, you will make reference to them. And the tribunal also will also be guided by those references. So it doesn't in any way, but the truth is that the tribunal bears the responsibility of making a decision on every matter, every point that you have raised. Yeah.
Thank you, sir.
So,
hello. Okay, sorry. So, Mr. Eze Matthew has asked that what's the duration for an average arbitration proceeding?
That is why I made that point earlier about what the objective of arbitration is and what the obligation of the parties, is also to the tribunal. I have been in arbitration that has ended under 1 year. If the parties are meeting the timelines with regards to filing and then obligations to the tribunal. I've been in arbitration that ended under 6 months. There are different kinds of matters. For instance, in arbitration, you can have what they call documents only. There are some proceedings that don't have to go into evidential hearing. If the question is about interpretation of a document or matters that low value arbitration, why do you need to call parties for to give evidence? Let them just file their papers, look at the papers and come to a decision. So it depends on the nature of the case. And then also it depends on how timely and how diligent the parties are in responding to the obligation to the tribunal. Yeah.
Thank you, sir. Somebody asked, when you were giving your presentation, you had said that divorce and tax matters are not arbitrable. An anonymous attendee has asked, what's the reasoning or what's the reason behind the non-arbitrability of divorce and arbitral and taxation matters?
Well, the reason is because our law says so. Then number two, it's for reasons of public policy. Arbitration is a private matter, and you have individuals. Most societies will want such matters that go on to the fabric of society. Things like these are things that deal with issues of public policy, issues that the society has a lot of interest in. So it is better to resolve disputes around them in a publicly accepted forum, through the courts, and also taxation. Of course, that is a very veritable source of revenue, for the government. So most government will not like private individuals, to make decisions, with regards to how much they will earn or how much they will, should not earn. That is why tax matters are things reserved for the federal high courts, by law. So it's essentially legal matter and based on public policy. Yeah.
Thank you, sir. Somebody has asked a question, an anonymous attendee. Is an arbitration agreement not contained in the contract, maybe contained in a text message between the parties valid? So if an arbitration agreement is not in the main substantive contract, but it's in a text message the parties have exchanged, would that be considered valid in law?
I'm sure Mrs. Kumi Roberts will give you a very good answer to that. But our new law now has actually, expanded the requirement of writing, and I'm sure that situation will come into the scope of writing requirements in arbitration, and it will be taken as having been written between the parties. Yeah.
Thank you, sir. Oluwaseun Ogunsanwo has asked a question. Said, can an award be set aside because it was not delivered within a reasonable time?
Well, the requirement of the law is that award should be delivered within a reasonable time. What then is reasonable? Now, in my practice, for me, the way I was trained, I start writing my award from the day either party makes a deposit of the cost of arbitration. And that is why you never see a situation where in my practice, I have delayed beyond 3 weeks, 2 weeks. If I have not published the award, it's because the parties have either not filed the representative processes or they have not met the obligations to the tribunal. So what is reasonable is therefore determined, can be determined by the context of the peculiar situation. Have you met the obligation to the tribunal? Have you filed all the papers you're supposed to file? Then why should the tribunal not deliver? And so if the tribunal delays unduly, that can also be a thing that can impinge on their on their standing, and that could actually be a basis for challenge of the arbitrators. But not, I don't know whether it's challenge to the award itself, because our law now is very clear as to the grounds on base of which you can challenge. So I'm not sure you can expand that, those grounds to include what the situation that you just mentioned. Go ahead, please.
Thank you, sir. Abdul Rashid Ahmed has asked, please, can you expatiate on the principle of separability of an arbitration agreement?
Okay, that principle simply means that, I think that's in section, it used to be section 12 before, but now it's in section 14 of the new act. It means that the agreement to arbitrate, which is a clause in the underlying contracts, is a different agreement, distinct from the contract that encompasses it. For instance, if the contract has 14 clauses, then the agreement to arbitrate is in the 15th clause. The law is that clause to arbitrate is a different agreement, and that even if the underlying contract is null and void, that agreement to arbitrate cannot be taken to be null and void, because the tribunal has to make a decision as to whether the nullity of the contract affects the agreement to arbitrate. So it simply means that the agreement to arbitrate has a life of its own, distinct and separate from the life of the contract in which it is embodied. Yeah.
Thank you, sir. Kabio Osunkunle has asked a question. He's asking, or she's asking, who decides the fees of the arbitrator and how is it computed?
Okay, usually the law is that the fees of the arbitrator has to be reasonable, compared to taking into account the time taking into account the quantum of claim, and perhaps the complexities of the matters. But the usual practice is that once the tribunal is constituted, tribunal will have what they call preliminary meeting. At the preliminary meeting, the tribunal will agree with the parties the scale of charges applicable to that arbitration. There are a lot of scales. There are the multi-door courthouse scales. There's the ICC scale, Charter of Arbitrator scale, and all of those scales. So you will apply the scale. For instance, if your claim is 20 million, you will apply the scale to that amount. And then if it comes to 1.5 million, that charges will be paid on 50-50 basis. The claimant will pay 750, respondent will pay 750. But if any party refuses to pay, the other party will be asked to pay on behalf of the claim, on behalf of the defaulting party. And then also, if there's a counter claim, the counter claim, maybe which is also in monetary forms, you will add the counter claim to the original claim and then charge your fees based on the collection of both the main claim and the counter claim. So, and both parties will pay on 50-50 basis. Yeah.
Thank you, sir. Anderson Jegbada, I hope I pronounced it right, has asked the question, and he's saying, can an international award be set aside in Nigeria?
Yes, it can. It can be set aside, and that is with recourse to the convention. There's a convention they call the New York Convention. Section 5 of that convention gives you an outline of the basis on which an international arbitration can be set aside. Yeah. So, and it includes if, for instance, the parties, didn't sign the agreement to arbitrate, or one of the parties was not given notice of the arbitration and didn't participate in it, or the award was made not using the law agreed by the parties, or the award is against public policy of Nigeria. For instance, now, if somebody brings an award to Nigeria for enforcement, award was procured by reason of fraud, which is a criminal offense in Nigeria. Now, of course, our courts cannot give ventilation to the enforcement of a right that's against our law. So the court in Nigeria can set aside that award and refuse to enforce it. But But that is if Nigeria is the seat. You can only set aside an international arbitration award at the seat of the arbitration. So my answer is based on the understanding that Nigeria is the seat of the international arbitration award. But if the seat is somewhere else, it is at that seat that you can go to, to set it aside. But you can enforce it in Nigeria. Nigerian courts can also refuse to enforce it if it offends our public policy or offends, all those grounds that I had mentioned previously. Yeah.
Thank you, sir. Adekule, he has asked, he said you said that sometimes arbitration, he said there are talks that arbitration can sometimes be costly as litigation, and he wants you to throw more light on this position.
Sorry, please. I'm not sure I got you, please.
Okay, so I said he asked that it has been said that there are talks that arbitration can sometimes be costly as litigation, and he wants you to explain if this is a true statement.
Well, I want to make a disclosure. First of all, I'm an arbitrator. And I know that arbitration cannot be as costly as litigation in courts. It cannot be, because I mean, what do you classify as cost? Is it the time? Is it the finality of the outcome? So it cannot be as costly as yes, of course. On the face of it, you file a claim, for 10 million in court, and then you're paying less than 5,000. You file the same 10 million in arbitration, then you're paying 1.5. But overall, all things put together, you will see that the cost of arbitration cannot in any way be compared to the cost, of litigation. And the effectiveness also and the efficiency of the process can also not be compared with what you will find in court. With due respect to, my Lord, don't let them cite me for contempt.
Okay. So Godson Ogwin has asked a question. He said, what if in a case where I'm representing my client, it's found out that the arbitrator is not abreast with the rules of arbitration? So he wants to know what he should do in such situations.
Why are you asking me? Ask yourself, why did you appoint the arbitrator? Didn't you know that's one, before you appoint an arbitrator, you must do a background check. And there's what they call procedure for interview of arbitrators. It's an acceptable practice for you as a lawyer before appointing an arbitrator to seek to have an interview in general terms, not specific interview on your dispute. For instance, there's a dispute on oil and gas, it's in maritime, and you're seeking to have an understanding of the arbitrator's views around that subject, to be sure that he understands it, and also to be sure that he or she also understands the rules applicable. Why will you go and appoint somebody who doesn't have a clue? Then you're asking me now what you would do. Consult me in my office so I can pay me fees.
Okay, somebody has asked, he said, is it only a lawyer who is an arbitrator that can represent a party in an arbitral tribunal? I think you've answered this question.
Yes, I have. Yeah.
Yes, thank you. Anonymous attendee also asked, what is the process of becoming an arbitrator? I think you've also answered it, except you want to still shed more light to this. He said, can a judge of a high court appoint himself or herself as an arbitrator in a case where he is an umpire? This is a question.
Well, let's be clear. Let's be clear, on something. The word umpire carries a meaning. Under the English Arbitration Act, Section 21 of the English Arbitration Act specifies for us who the umpire is. It specifies to us who the umpire is. Umpire is not the arbitrator. Umpire is a third party appointed by arbitrators to give clarity to certain issues that have arisen in the arbitration. So I don't know what you mean by the judge appointing himself or herself as the umpire. We don't have provision for umpire in our law, but I mean, what it means is that what it means is that the judge who is sitting as over a matter in my view, cannot, and I don't see how that can apply, cannot appoint himself or herself, as umpire, because umpire is usually appointed by the arbitrators. Yeah.
Thank you, sir. When you are answering the question initially on trainings, you had advised young lawyers to participate in training. Somebody has taken this question further and asked that how long can someone train to become an arbitrator, and should the training be specific? And there are three questions actually. First is, how long do I need to train? Second, should these trainings be specific? And third, does an arbitration lawyer practice at the regular courts?
Well, like I mentioned to us, there are institutions that run trainings and certifications for arbitrators. And they have different layers. I will use Chartered Institute, for instance, as an example. They have different layers of membership. They have the entry course, they have the membership course, fellowship course, and the chartered arbitrator. And each of those trainings has, a limitation period. For instance, entry course trainings usually are done in 1 day. But of course, you are expected to have read material sent to you and then write a multiple test, examination. Membership training also is the same thing. They also send you materials which you will read. You go do the face-to-face assessment, and then the examination. Fellowship also the same thing. But in the UK, they have what they call the elements of contract, or what they call the law of obligation, and the elementary principle of evidence, which is also the law. But as lawyers, they will waive all of those things for you. So usually, before you become an arbitrator, you would have gone through trainings of not less than 2-3 years that has enabled you to rise from as entry course, membership course, and fellowship. And as you're doing it, you're also getting practical exposure by either being registrars to tribunal, or also being involved as an arbitrator yourself in what they call small claims arbitration, like what you have in Lagos Court of Arbitration. They have what they call the small scale arbitration, where they appoint young arbitrators, to take over, small matters of tenancy, small scale arbitration of maybe 1 million, 2 million, 3 million, 4 million, 5, and be gaining experience, and then be going on in that way. So there is no specific time. It depends on your own speed and how well you understand, how well you can apply yourself to the demands of that training and of that institution. Yeah.
Thank you, sir.
Thank you.
Blessing Obiazo, she's asked the question, and she's saying, in the absence of a review mechanism for challenge of arbitrators in Section 9 of the ACA, I think that should be AMA, I'd led to the question on whether courts have authorities to review tribunal's decision, and whether such review will involve a rehearing or a review of the grounds for challenge of awards.
Okay, I will ask with reference to the law as we have it now in Nigeria. The law, like I said, what you can do once an award is published is to apply for a set aside. And the law allows the tribunal that, look, the area of your complaint, can it be separated from other areas? Or is there a possibility of referring the matter back to the tribunal for tribunal to rectify it? Those are options that the court can weigh. So if the court is of the view that, look, rather than set aside the whole award, we can actually isolate a part of it and allow the tribunal to rectify it, that is all well and good. Or if the tribunal feels that the infraction is grievous, that cannot be segmented, that could be a basis for the tribunal to set aside the entire award. It depends on what the situation is. And for you as a lawyer to understand what the law is, then apply it to your respective situation. Yeah?
Thank you, sir. Thank you. Suleiman Sadesi has asked a question. I think the question is just trying to say that, can an organization, as a corporate organization, engage in ADR?
Can a corporate engage? How do you mean a corporate organization? How? Engage as a party? Of course, yes.
Party, yeah.
You can ventilate your rights if that is what you have in your agreement, whatever agreement you signed up to, or if your counterparty is willing to, accede to you having a submission agreement. Of course, you can. Yeah.
Thank you, sir. Chioma Uzoma has asked, she said that you had previously stated in the presentation that parties are bound by what they agreed with respect to the applicable law. So she's asking, what is the place of institutional rules in institution-based arbitration? And the second question she's asking is also, what role does the law of the seat of arbitration play? I know you've answered it briefly before, but perhaps you may wish to explain on it.
Okay, let me clarify to Chioma, the different interplay of laws in arbitration. Now, we must make a difference, or we must have an understanding of the difference between substantive law in arbitration and the procedural law. Substantive law is a law that defines or delimits or outlines the rights, the contractual rights of parties in every arbitration. For instance, you can say Nigerian law will apply, to the rights of the parties in a substantive law. But then also, if you talk about procedural law, you are talking about the law that will govern the procedure around the arbitration. That is what I meant by parties making a choice of both the substantive law and the procedural law. You can have an arbitration in Nigeria, which as is sit, which means Nigeria's law will apply to the procedure, but then English law by election of the parties might apply as a substantive law of the arbitration, which means you define or determine the rights of the parties with regards to English law. So let's have that understanding. For international arbitration, substantive law may be different from the procedural law. That's the law of the seat. So, but in Nigeria, for domestic arbitration, the substantive law is usually Nigerian law. Then the procedural law is also our arbitration law. So it's good to have that, understanding of that, those differences. Yeah.
Thank you, sir. Levi Shapira has asked a question. And the question borders on principle of functis officio. So he or she is asking, can arbitrator amend names of parties after the award?
That is a very, very good point. And that speaks to what you must do as an arbitrator, which is to pay attention to details. I'm aware of a case in Romania that went up to the Supreme Court. The party challenged the enforcement of the award against his client, saying that the party against whom the award was given is not his client. Why? Because of a mistake in the spelling of the names, Evan and Evans. Are you familiar with that story of Evan and Evans in Nigeria, in our political story, in our political history? Somebody says, Evan is not my name, Evan is not my name, but my name is Evan. So it can happen like that also in arbitration. The losing party is eager to look for loopholes in the award as a basis for resisting enforcement. So I'm not sure that is a mistake the tribunal can correct on its own, because the losing party will insist that you want to bring my party into an award that was not given against my party. So he can resist it and say that is not a typo error that the tribunal can can amend. But that is up to the court to decide as to whether, looking at the the whole scenario, looking at the facts of the case and the circumstances of the case, whether the court can allow. But the important point I want to make is that as an arbitrator, I pay very close attention to my award. It is better to write the award and leave it, because sometimes when you're writing, what you have in the paper may not be what you have in your head. So, but when you leave it for about 2-3 days or even a week, and you go back to it and read, what you have in your head is not there anymore, and you're reading. So you can be seeing some things that are incorrectly put that you can correct. You must pay attention to to your drafting. Yeah.
Thank you, sir. Chidbem Akubwe Ozondo asked a question, and he's saying, where 3 arbitrators are appointed, what happens when one of the arbitrators become incapacitated and unable to carry out his or her activities?
It's very clear. That one is fairly straightforward. I mean, the law is clear. The same process you use in appointing him, same process you use in replacing him. That's all.
Thank you, sir. Another person asked the question, when you were giving the presentation earlier, you had stated that evidence act does not apply to arbitration. but rules of evidence apply. So the person wants you to explain what you mean by that. That's OB and OA.
Okay, yeah. As lawyers, I'm sure lawyers will be interested in that. So they'll not go to courts. If Section 256 of the Evidence Act is very clear. You could just take that law and look at it. It says that the Evidence Act do not apply to arbitration as a matter of law. And then if you look at, I think sections 41 or 42 or so, I will speak more on this on the 19th, on the 18th with Mrs. Roberts. It's also very clear that what applies to arbitration is the rules of evidence, rules as to materiality, as to admissibility, as to weight. So it is not a question of whether. So you cannot come to me as a tribunal and be telling me that I should not admit a photocopy, because foundation has not been laid, or because it's not from proper custody. Of course, I will not pay attention to whatever the lawyer is saying. So that's what you don't object in arbitration based on Evidence Act. You don't at all. Yeah.
Thank you, sir. So I think it's 3:50. Maybe we'll just have the last question before.
I was going to ask for protection of Toby.
We really enjoyed your presentation, and everyone wanted to ask a lot of questions. I just had to select from the list of questions. So just this last question. And this is from Vito Ewuze, and he's asking, he said, is the statute of limitation applicable in arbitration proceedings?
Okay, that is a very, very important question. That is a very, very important question. Of course, it is applicable, but the new law has changed the starting point of that statute with regards to arbitration matters. Before, but there's this case of fan milk or city engineering that says that the starting point starts from the time of the cause of the time the cause of action arose, which means that if it took you 6 years or 5 years to do the arbitration, or even before commencing it, your time is already running. But the new law now says that it starts from the point when implementation of the award is, when there's a default from the day the award is published. So it has not elongated the time. So yes, it is applicable, but then the starting point, has shifted from where it used to be before, to where it is now. Yeah.
Thank you so much, sir, for the presentation. So just give it to Mr. Erujikwe, the moderator.
Thank you very much, Peace. Thank you.
Thank you very much, Peace. Thank you for standing in today. It's always good to have young people participate in what we do, and it's always good that when you're called upon, you answer. So thank you for that. Dr. Madumere, what can I say? What a brilliant presentation today. I mean, I think the question and answer session was actually very illuminating, and it's exciting to see that we have as many as 89 questions still outstanding in the Q&A box. That is really remarkable. And it shows the level of interest that people have in arbitration. And I'm sure it also shows that they were following and keenly the presentation that you made. Dr. Madubere, it's always good to see you. You always answer when we call you. And there's the reason why you're a trustee of the Tanzania Institute of Arbitrators UK. And you've shown that quality today. Thank you very much for coming today and for making this presentation all the way from Kenya. We do not take it for granted. And I must say to all the participants that we shouldn't take for granted what our facilitators do. They spend time to prepare for these trainings. They come and make these presentations at no cost to the NBA at all. It is voluntary, it is free, it is meant to help colleagues build their capacity and develop in various areas of the law. And I know that we can never afford the type of money that Dr. Madubere will charge for an hour of his time or 2 hours of his time as it is today. But what a brilliant way to start this series. Thank you very much, sir. We are grateful. We look forward to seeing you at the end of the series when you come to talk about the Arbitration and Mediation Act 2023. Thank you so much for all that you do. Thank you.
Thank you very much, David. Thank you. It's always a joy to be part of what you do too in the Institute. Thank you.
Thank you, sir. And then to everybody that participated today, we are grateful. We have some senior colleagues who joined in. Mrs. Fumi Roberts earlier, thank you very much. Dr. Rosemary Chikwendo, thank you very much for joining in. Tomorrow is another day. We will start at 9 a.m. tomorrow. 9 a.m. It's important that people take note of that time because it's a little bit unusual. So 9 a.m. tomorrow, we start again. We'll have Professor Daniel Wilmot making a presentation from London tomorrow. So it'll be good, and we'll be talking about arbitration procedures. So I look forward to see you all tomorrow. Thank you very much for participating today, and God bless you all. I also want to thank the coordinators, Akino Misade, Rachel Osimu, my other colleagues at the Institute, Sarah Ajidola, who is here, and Wole of NBA-ICLE. And then Peace for joining us, very impromptu, but doing an excellent job. Thank you very much, Peace. And thank you for always reaching out and offering to be of help. That's the kind of spirit you want to encourage in the NBA. God bless you all, and see you all tomorrow. Thank you.